All right.
Good afternoon, everyone, and welcome to the Legal Advice for Business webinar. We'll just give it a couple of minutes to allow the attendees to join. Today's topic is leasing, particularly the abatement and enforceability of rent at this time. I'm Nick. You've seen me earlier in the week, and this is Hayley. Hayley's our property expert at Hitch Advisory, and Hayley will take us through in a few moments, when we get everyone on board, some of the issues that you might be facing in relation to your rent. I'm sure we'll have both a mixture of landlords and tenants in the webinar today, so we'll try and take quite a balanced and accurate view. I'll just give it another minute till 2:33 and then we'll kick off. Does anyone have any questions off the bat while we're waiting for others to join that they want to hit us with in the question and answer section or in the chat box? Or it can be employment related, it can be stimulus related, it can be just general crisis legal related. It doesn't have to relate to leasing. No, all right, that's fine. So we've got a good little group in there, so we'll get started. As you know, the intention of these webinars is just to provide everyone with a base level of information that you can either go away and self-educate using the different government links that we try and provide you, or alternatively know that you need to seek some external advice and get it as quickly as possible. Just a typical lawyer's disclaimer that everything that we discuss is general in nature. All of the government announcements are moving extremely rapidly, and we would encourage you to seek specific advice tailored to your circumstances if you're unsure, or just in general, really. So I guess, what have we seen over the last couple of days? We will be going through tomorrow at our last sort of daily webinar, just to round out the stimulus and the lockdown updates as at tomorrow. I'm sure you're all reading the media from your various states and territories. Where we are in New South Wales, there's definitely discussion of further lockdowns to follow. I think for some of you business owners, that will be a massive sigh of relief, because we've spent sort of the last 72 hours advising people on whether they were or were not entitled to exercise stand-down rights under the Fair Work Act. For those of you who are observing the media, you'll see that regardless of, it's probably not for me to cast too much of an opinion on it, but you'll see that even some of the businesses that do not have a direct government-ordered shutdown, such as a lot of the large retailers, are putting off huge thousands and thousands of people under stand-down provisions in the Fair Work Act. I guess that's the business, the CEOs and the managers basically sending a pretty loud and clear message to the Commonwealth Government that they are hurting and they need to take action despite the absence of a shutdown, and that is what it is. And I think it would, whilst technically they may or may not have stand-down rights, it would be a very brave government at the end of this catastrophe to go back and take action against everyone that acted in a proper and prudent manner. Probably the most interesting one we saw overnight for some of our clients was the backflip on hairdressing. We still can't get our heads around, pardon the pun, we still can't get our heads around how someone can comply with the 1.5 metre rule and obtain a haircut. But maybe there's some Edward Scissorhands kind of extension arm stuff going on in the industry that our clients don't know about. Okay, I've got a couple of questions. Perfect. So I've got one of my trusty accountants giving us some help here, and yeah, today is the leasing topic, so this is perfectly relevant. And this the comments that have been made, and they're a continuation from I believe Monday's comments, as to whether self-managed super funds can basically put rent on hold. And this is very common where small to medium business owners own both their commercial property and the trading entity and pay rent. And the comment that's been made in the chat box, which is perfectly accurate, is that it could potentially be a breach of the superannuation legislation if action is not taken for banks to defer if legislation changes aren't made in order to allow the abatement to occur, and also to allow banks to defer interest on those SMSF limited recourse loans. So that's an important point to watch. All right, so we'll just click through to today's topic on rent. So I think for most of you I'm not sure who was here on Monday and who sort of joined later in the week, but obviously Monday we started and we dealt with stimulus. Tuesday we dealt with employees. Yesterday we dealt with the debtor-creditor relationship and refunds and credit notes. Today we're going to deal with occupancy and the landlord-tenant relationship, and then tomorrow will just be a wrap-up of the week. It'll be likely that we'll probably go to once or twice weekly thereafter. To be honest with you, we're seeing a lot of our clients and a lot of businesses that we sort of hear in the industry are coming to a pretty big grinding halt, and I'd be very surprised. Sure, there'll be restart issues, but I see those as being relevant maybe in May, June, July, but not March and April. So I guess it'll probably the content will flip a little bit to reactive content to the government changes, and it'll change to being both interviews of business owners and stakeholders, as well as some proactive content that can help people get back on their feet in the back half of the year. So hopefully that can be helpful. Okay, so I'll hand over to Hayley, who will take us through some of the key contractual positions in relation to rent, and we'll go from there.
Okay, thanks, Nick. I think that's a key word there, that it's the contractual position, because at the moment we're still waiting to get a clear position from the government as to exactly where we stand or what measures are going to be put in place in relation to the tenant-landlord relationship. Earlier in the week, the Legislative Council of the New South Wales State Government did agree to pass some amendments to both the Retail Tenancies Act and also the Residential Tenancy Act to give some relief to tenants who are unable to pay their rent over, say, the next 6 months. But we're just waiting for a final announcement from the government as to exactly how that's going to look. And we're expecting that to come through. I'm thinking it's going to come through tomorrow, but like I said, we're just waiting to hear from the government on that. So I guess for us, in the meantime, the majority of questions that we're starting to get from our clients are saying, what can I do? The trade, the foot traffic passing my shop is nowhere near what it used to be. I can't afford to keep paying my rent. What do I do? Am I able to stop paying it? Can I get out? Does this classify or count as force majeure, or what are my rights? So really, the news isn't overall that great from a strictly legal, strictly contractual perspective. If we think about first going to the force majeure. So I've had a few clients call me and say, well, surely there's a force majeure right in there and this is it, and I don't have to keep going. The reality is that this concept of force majeure is a contractual concept only. So really, it will only come into play if you have a clause to that effect in your lease. Generally, the concept talks to the idea that I am unable to comply with my obligations under a contract because something has happened that was not foreseeable. And because of that, it's a reason beyond my control and I cannot comply with my obligation. So we then look to the fact, well, first of all, does your contract or does your lease have a clause in it that says that there is a force majeure event, has a force majeure event clause in it? If it does what we're going through right now as COVID-19, a global pandemic, does the contract define a force majeure event as something that includes a global pandemic? Because each contract will have its own version or its own definition of what it defines as a force majeure event. Some contracts will have an exhaustive list where it spells out every type of situation that it wants to include or capture under that clause. For example, war, an act of God, a strike, an industrial event, a lockout, whereas others will talk more broadly to the concept. So what will happen in your individual circumstance is really going to depend on what the wording is in your individual lease or your individual contract. The next step is, if you are one of those few people that have a commercial lease with a force majeure clause in it, has a force majeure event occurred? And what obligation under your lease are you now unable to comply with as a direct result of that force majeure event? That's very difficult for us to answer broadly, and it's very difficult for us to say on a broad level, yes, you have a force majeure event, or no, you don't, without actually looking at the individual terms of your contract. But from your perspective, if this is something that you think, oh, look, I've got one of those clauses under my contracts or under my lease, that's your starting points. That's where you need to. If you don't have one of those clauses under your contract or under your lease, the next concept that might be of use is a common law doctrine of frustration. Under that element, though,
can I add something just before we go through frustration?
Yeah.
The kind of angle that, so the long bow that many or a few legal commentators are trying to draw there in relation to a force majeure clause is, as Haley says, what clause can the tenant or the landlord not comply with? Well, for the tenant, we know that the tenant cannot comply with the essential term, which is in every lease, to pay rent on time, periodically, generally in advance. There is legal commentary to say, well, that's not enough. It's not enough to invoke the force majeure purely because someone can't pay money. So what some legal commentators are saying is, okay, well, perhaps it's in fact the landlord that's triggered the force majeure, because the landlord cannot lawfully provide the tenant with quiet enjoyment of that property for the permitted use as a result of the government shutdown. Now, in our view, at first blush, firstly, we see very, very few leases with force majeure provisions in them. And secondly, tenants would be drawing some very, very long bows to get there. Before Haley jumps into frustration, you'll see that Premier Investments, Solomon Lew-backed Premier Investments, has basically shut all of its, I think it's Jeans West, Smiggle, and a couple of other retail brands today, and they've actually come out with an aggressive stance that they will not be paying rent. So they're the kind of things you're seeing in the market, and that's where you're seeing a difference between what Haley and I can give you from a strict legal perspective, which is get ready to pay your rent 1 April next week, and what people are actually doing in the market. Now, for our landlord participants that are on the webinar, I guess that undoubtedly it's legally wrong for that to occur in my mind, in the absence of a force majeure clause that bridges that gap. But I think landlords would be burying their heads in the sand if they don't have some kind of strategy ready after the state governments make their announcement, hopefully today or tomorrow. Just landlords need to be ready, because whilst you can say, oh, my lease says they've got to pay on time every time, the simple reality is that people don't have the turnover. And sure, you can go and cash some bank guarantees, but you do need to think more broadly about, well, what am I going to do both now looking down the barrel of April and a couple of months of shutdown? And then, probably more importantly, how do I make my premises, my offering attractive June, July, August, September, when there's going to be this absolute glut of vacant space on the market? So yeah, contractually, landlords can sit on a pedestal. Commercially, you've got to join the discussion like everyone else.
And on that point as well, even if you did have a force majeure clause that was available to you and you know, you fell within all the parameters of what constituted the event, it may not be that you can stop paying rent forever or for X amount of time. You still need that commercial negotiation in place to be able to get that outcome that you're looking for. What is actually available to you under a force majeure clause, again, turns on phrasing in the lease or in the contract, which is why those commercial negotiations and those open discussions are really what's going to be of most help and of most importance during this time for both landlords and tenants, to ensure that everyone can continue with a position that they can accept, not necessarily what they're going to be happy with, because I don't think most people are going to be too happy at the moment, but it's a position that they'll be able to accept.
Yeah.
The next kind of legal concept.
Sorry. On that bill that came through on Monday or Tuesday night, the New South Wales bill that Hayley mentioned at the outset, that we haven't seen the regulations that flow from the piece of legislation. Interestingly, it talks more about eviction. So I foresee that what the government will do is they will say, it's a hiatus period of 6 months, like with the statutory demands and the bankruptcy notices that we spoke of earlier in the week. However, in relation to what happens to that sort of rent that should have been paid April to October or March, September, I don't feel that the government would go as far as to step in and do the deals for landlord and tenant. I think those deals will still need to be brokered out at some point. They will say, well, you can't take action in the point, but you're all big enough and ugly enough to go away and try and sort it out during that period. And that's where, you guys should be looking for a force majeure clause in your lease to see whether it exists, but we see maybe 1 in 10. Sorry, Hayley.
No, that's all good. The next concept that I wanted to raise was the doctrine of frustration. So it's not a strictly contractual concept, it's a concept at common law. We've had some clients try to argue the point that I shouldn't have to pay my rent because I don't have customers coming in, therefore I'm unable to perform the contract, therefore it's frustrated and the contract can't continue. The doctrine of frustration is a very tricky one and a very fine line that needs to be tread. First of all, you really need to consider, is this lease that I'm in or this contract that I'm in something that I want terminated for good? Because that is the end result of successfully arguing that a contract is frustrated. How it's going to work in real life is, if, for example, there was a concert that was supposed to happen and now legally that concert can't go ahead, and you were supposed to be providing the lighting services for that concert, which is now at an end, that contract is frustrated because legally it cannot go ahead and neither party can uphold their end of the bargain. If, however, your store is still legally allowed to open and it's still legally allowed to trade, but you have received reduced sales because the foot traffic's down, people are staying at home, or people don't want to spend money, we can't argue under the doctrine of frustration that the contract can't continue merely because you have suffered hardship or merely because you've got a loss of sales. So really what we need to be looking at, has this situation, has COVID-19 made it impossible for me to be able to perform my obligations under the lease, such as payment, Or has it just merely made it harder or more costly for me to be able to comply with that obligation? Where this doctrine may come in to assist is if you are not legally able to operate from your site. For example, if all shopping centres become closed and you're not legally able to get access to the site, then that's where we might be able to rely upon this doctrine. But otherwise, I think it's going to be a very difficult concept to try and hang your hat on as a tenant or even as a landlord to cause a contract to be at an end because of this doctrine. So again, I guess this is not a helpful, strictly legal concept to be wanting to give you some guidance on as to how to manage your relationship with your landlord or with your tenant, which again just comes back to the fact of having this commercial discussion and opening up that dialogue between landlord and tenant as to how to progress this from both sides as we move forward.
I think probably the best practical example of that would be, I think the best one, a practical example of when frustration, in our opinion, would not apply is a restaurant or a hotel. So you could say, well, that the tenant signed up to that lease and said, well, yeah, we want to take on that site. We want to take on that site and we think we can operate a good, viable business from there. The government's come out and said, well, no, you can no longer offer eat-in, dine-in options. You can only offer takeaway. Now, that is a hugely different proposition on a commercial basis for any tenant. However, in our opinion, it doesn't have legs under the doctrine of frustration because whilst the contract can still be performed, the tenant is likely to be bleeding in terms of its viability and its profitable, probably unlikely to be profitable, but in terms of its revenue and its viability. So that's one example. People would say, well, what about it? There's sort of a flow-on effect from a government order. And we say, well, no, we don't think it bridges that gap. Conversely, if you had a premises a premises, that was, as Hayley said, if next week all shopping centres are shut down and you definitely want it out of your lease forever, there's an argument that the landlord can no longer provide you with quiet possession. Sorry, I lost everyone there for a minute. One second.
Oh yeah, I can see.
I'm back. We've got our participants back. Can you hear me, Edge?
I'm back, yeah.
So yeah, whilst we can sit here and hypothesize about the doctrine of frustration, the commercial reality is that businesses that are struggling are not, unless you're maybe a Premier Investments or another huge retailer that has the bankroll and a need to kind of test this stuff. So tenant is going to be well advised to enter into a commercial negotiation as opposed to go and start to play around in old English case law. I think that's a fair comment, isn't it, Hayley?
I believe so. The other point to note with that doctrine is that it will really come down to how long you can't access your site for. Because if it's 2 weeks out of a 5-year contract, then it's not going to be upheld because it's an inconvenience as opposed to the contract not being able to be performed. If it goes on for, say, a year, I think that's a different story.
I agree with that. So you're left with, check to see if you've got a force majeure clause. Now, some of the retail leases that we have seen and that we deal with on a regular basis have a material adverse change clause. Now, most of the time when we see them, they say, okay, if traffic foot flow drops by X%, then the landlord and tenant will use reasonable endeavours to sit down and have a discussion. It is very, very, very rare that I would see a lease that says, and we've tried, when we've acted tenant side on many occasions, we've tried, I've tried to get provisions in there to say, if foot traffic drops by 10%, so too does rent. And we've probably got it a handful of times. And it's just the bargaining power of a landlord, and there's no problem with that. But it's also worth the try when you act tenant side as well. So if you do recall when you signed your lease, some kind of provision that guaranteed passenger flow or guaranteed minimum operating hours or anything like that on behalf as a hard obligation on the landlord, then they may be some other angles too. Are we sort of running and clapping in the streets that we think those provisions exist in most leases? Absolutely not. And that's why we're sort of for the tenant clients that we act on behalf of and for the landlord clients, we hope that there's some sort of sensible government intervention. The various pieces of retail legislation across the country do have some say that tenants may be entitled to abatement or compensation during a disruption period. However, typically they're canvassed on the basis that the landlord caused the disruption. So there was talk earlier in the week, and I believe even in America, Centre closed their Westfields in the States. Now, I believe that was done voluntarily. Had that occurred or even if it does occur in Australia, and there may be an angle to say, okay, well, you, Mr. or Mrs. Landlord, chose to close your site voluntarily pre-government shutdown. You've then caused passenger flow to drop. Therefore, you've caused a loss in revenue. I imagine that most, if not all, landlords would not shut their centres until ordered. But yeah, if anyone's heard anything different in the market, please let us know. We can go on questions. So unless Hayley has anything else to add, we might go to questions.
Yep, go to question time, I think.
Perfect. Okay, so in case of the gym, I think we've had a lot of fitness people in here this week. So hopefully you're training hard in your backyard at this time, unlike me, who should be. In the case of a gym who is forced to close down, would you be able to argue frustration? Okay, so first question, you never want to go back in. That's the first hurdle you've got. Before you even engage a lawyer to look at your lease, you have to decide that you never, ever, ever want to go back into that site again. If we get over that hurdle with you, then the next step I would say is, okay, are you prepared to pony up a substantial in the multiple tens of thousands of dollars to litigate this when we give you a clear direction that this is full federal court and high court case law that deals with these issues. If you're still saying, yep, want to leave forever, yep, happy to throw a substantial amount of money at it, lose or draw, then we're still having the discussion about, is your contract frustrated? The third question, as Hayley said before, is, okay, well, did the Commonwealth Government order the gyms could be reopened on the 1st of May? If they did, then I think we've not got a worthwhile discussion to have. If, however, the Commonwealth Government were still sitting around in September and gyms are closed, gyms are closed, and no one can train, and you've still decided that you never ever want to reopen from there again. And maybe at that point, the kind of thing a gym owner might be thinking at that time is, I'm going to have to put my company into liquidation. This is not a viable proposition for me to reopen. And what you're looking at that time is some defences as to a personal guarantee claim. So would we ever recommend that in relation to a single site gym that you take on something like this? I think you would get a more cost-effective commercial outcome by having the discussion early. I've just got another question we'll go to. My lease is about to end in April. Should I re-sign a new lease or try to go month to month? What do I do about my equipment if I don't re-sign and we're all in lockdown? I have 30 days to get out. Excellent practical question. Well, I can tell you what we are going to do with our lease that expires on the 30th of April. We probably won't re-sign it. But look, that part of your question is really commercial in nature. That's totally up to you, but I can definitely commercial logic there about month to month. What do you do about your equipment? Okay, so that's an interesting point. If you feel that if you're in a position where prior to last Friday, and I take last Friday because the shutdown measures came in on Sunday. If last Friday you had a viable business and everything was going along well and you had full intentions to renew your lease, then I think we do need to look at a solution for your equipment, because at some point you're going to want to, you're probably going to want to have it again, and you're probably going to want to use it, whether it's in that premises. Or updated the question and say, yep, you did have a business last Friday, which is a totally different proposition to if you'd said, no, we were struggling, we were dead in water last Friday, and this is the nail in the coffin, in which case I'd say, okay, now we need to start to turn our mind to what personal guarantee exposure do you have, what equipment financiers do you have, et cetera. But let's go back a step and say, no, you do want that equipment and possibly that premises in some way, shape or form. The answer to your question is, what happens if I don't want the premises, but on the other hand, I can't go and get my equipment because we're all in lockdown? I think even in the absence of a force majeure clause, it would be extremely unlikely for any landlord where the entire country was in lockdown for them to basically either sell your gear on Grays Online or chuck it out on the curb. I see that as almost an impossibility. And I think the way you would protect yourself there would be to send a respectful but pleasant notice to say, look, lease has expired. Unfortunately, I'm not in a position to renew. You've rejected my request for a month by month. And I just let you know that because we're all locked down pursuant to Commonwealth Government order, I won't be in a position to collect my equipment. If you have any intention to deal with it, please give me at least 7 days notice. That kind of thing would be your self-help remedy there. So hopefully that answers that one. And it doesn't look like we've got one more. Perfect, no problem, our pleasure. All right, so do we have any other questions on the landlord-tenant relationship, the stimulus measures, the employment relationship, or any other things that are affecting your business from a COVID-19 perspective that you think we may be able to help you with or point you in the right direction? We might get an early minute. I'll just give you all 1 minute to have a think about it, and then we'll wrap things up for what is it, Thursday. So we'll definitely, next week we'll do our twice weekly or once weekly updates, and we'll try and get some panelists on as well, both from industry and from other professional advisors like insolvency practitioners and accountants and so on and so forth, and insurance brokers. I know there's a lot of frustration in relation to business interruption insurance policies that aren't answering the call on pandemics. I certainly feel your pain there, and I hear you there. But I guess, and I don't see why the insurance companies wouldn't participate in a product for pandemics. If you can ensure, if their actuaries can make a quantifiable assessment on the regularity of bushfires, then why can't their actuaries make a quantifiable assessment on the regularity of pandemics or epidemics? I see that they will probably open up, and they will actually. I think in 12 months' time, you will see that the new buzzword is pandemic or virus insurance, and I think that'll just go absolutely nuts. So that's an interesting thing. So if any of you are in the insurance market, I'd be interested to see whether those sort of products, whether you think those products will come. All right, we've got a few questions. We've got a thank you. We always like thank yous, no problem. What about sale of premises that was going through 2 weeks ago and that was to go through in 2 weeks and they're required to move out if we're in lockdown? Okay, Hayley, what are we going to do if we've got a deal that's meant to complete in 2 weeks and we're all locked down? I haven't turned my mind to it.
I think it's a very interesting one, and if we can't legally get in there to move out, then I think commercially people are going to be having that conversation with each other and reaching that agreement. I'm already seeing it in property contracts where we're trying to include COVID-19 clauses in there as to if someone needs to go into hospital or into isolation, as to why we can extend the settlement period. So from a strictly contractual perspective, again, there's going to be probably nothing in your contract that allows for that at the moment if it's already been entered into. But if it is something that happens, I'd like to think that common sense and commercial discussions are going to come to the front, and everyone's going to realise that no one can move. So from a practical perspective, I don't think I'd be too concerned because I think most people nowadays and their solicitors are being quite practical with what's going on. We're all in the same situation. We're all kind of living day by day to see what changes are going to be made each day.
It's been, and I haven't looked at any finance docs in the last month because people have been preoccupied and not doing debt deals. I can't recall off the top of my head when loan docs come out, because typically loan docs are signed, but does it give the bank a right to pull out if they're unforeseen? And that's where it's not worded. Like I do recall seeing some unforeseen circumstance language in banking docs and loan docs. I'd just be curious to see, in light of the market, whether the bank will still, particularly for resi, whether the banks will still be advancing funds when it comes to completion day, or whether purchasers of resi property are going to find their banks getting a little bit shy, in light of the fact that on the other side of the coin, there's a whole mortgage deferral system at play. But we'll just have to wait and see, I guess.
Well, in saying that, I've just had 3 separate clients have their loans formally approved today.
Okay.
So I think it is still moving in that respect from a finance perspective.
Was the one that was close to 10 mil?
I haven't seen that one yet.
Okay. All right. All right, we've got another one. If you have 12 months of your lease left, is it better to hold off lease payments, effectively keep cash flow and sort it out later, or pay and potentially have nothing left if it goes on for months? Totally a commercial call, and I think it would be wrong of me to suggest what you should do on here in light of the context that Hayley and I have given from what's the true legal position. I think if you're talking about 1, 2 or 3 sites, it would be wrong of us to suggest anything other than don't withhold rent and go rogue until you've at least had the discussion with the landlord. If you've had the discussion with the landlord and you've had a blanket refusal with no reason or rationale, then I'm not going to give you the answer to your question, but you revisit your question. So, okay, first step, go and have a chat. Don't get a terrible answer no one's ever going to be happy with the answer. So all tenants are sitting back going 100% abatement, never to be clawed back, complete rent holiday during the shutdown. That's what the tenants are saying. The landlords are on the other side saying, no, totally not. We don't have force majeure clauses. If you want your site back, we're going to take all your bank guarantee to clean up the arrears. You'll replace your bank guarantee in 14 days and you'll come back in and you'll pay rent on time every time. Like any mediation or any negotiated position, everyone walks away with typically their least bad outcome. So yeah, I think that's where heads need to be. We've got one more. What about the clause? Tenants?
I also think that we might be.
You go.
Sorry, this is the world of remote working, hey? I think we might also be having a slightly different discussion tomorrow after the government comes out and reveals what its plans are or what its package is. So I think it's also, this is one of the, with everything to do with COVID, it's evolving. And I think particularly in this area, there's going to be some changes and hopefully there'll be some clear direction once the government lets us know what its position is.
And it's a relationship that many of you that do need your premises can't just simply walk away from. The landlords the tenants need places from which to conduct their business, and the landlords need tenants who provide them yield, which goes to their overall underlying property value, which then backs up their valuations for their banks. So you're entirely intertwined with positions that need to be solved. And it's not, I don't feel that in the current climate, it's a situation where someone can chest beat and say, we're in a really strong position and we're not even going to have a discussion. And I think that's probably the good thing here. And I hope that in the light of COVID-19, people will start to treat each other with a bit of respect and a bit of, good business behaviour, as opposed to just coming into meetings or negotiations and saying how wonderful their position is and walking out. So that would be my only other comment. Okay, we've got one last question, and I think we're nearly at 15:15. Tenant's quiet enjoyment. The landlord must allow the tenant to occupy and use the premises without the landlord interrupting or disturbing the tenant, except where the lease allows the landlord to do so. That's interesting. If that's the exact wording from your lease, almost like a school class, I'd ask you guys, what do you think? Do you think that's enough? So the clause seems to say the landlord must allow the tenant to occupy and use the premises without the landlord interrupting or disturbing the tenant, except where this lease allows the landlord to do so. So does that amount to frustration? Do you want to try and answer that in the chat box in one word? I'll get a quick straw poll. Given it's 3:15, I'll give you the answer. I think entirely not on the language of that clause, because that clause there talks about what the landlord must do. You know, the tenant can rock up and unlock their premises and go in and sit inside. The fact that they can't trade from there is the Commonwealth Government and the landlord's issue. So I think on the language of your clause, entirely not. That clause, on the interpretation of that clause that you've sent me, the lease is not frustrated because the landlord is not stopping you from doing anything. The Commonwealth Government is. Hayley, am I wrong?
I agree with you there. And then a step further to that, there's likely to be a clause in that lease that provides that it talks to what is lawful and what's legal to do. So if the government is preventing you from operating, then no, that's not the landlord's fault.
Yeah. All right. Well, I think that's everything for today. We will. I think it was day behind on YouTube yesterday because we were doing thousands of stand down notices for poor employees. So we will get both today and yesterday up on YouTube this evening or in the morning. Tomorrow will be a round out of the week in relation to stimulus and hopefully an announcement on rent. And then next week we'll go to weekly, and that will be announced by email, direct mailer, and LinkedIn in the next couple of days. But thanks everyone for their participation so far. I hope it's been helpful, and all the best overcoming some of these challenges at this time. Thanks.
Thank you.